This is a lecture for statutory interpretation, and we are going to review the Canons of Construction. The Canons of Construction from common law. These were popular in the common law era before courts started relying more on legislative history. They've seen a resurgence in popularity with the modern textualist movement. And we're going to start with a section. The casebook that I use in my class divides canons into semantic canons and substantive canons. The semantic canons are more almost like maxims about communication, or the way words function within sentences and paragraphs. Substantive canons are, which we'll get to later in this little talk, are more policy judgments about things, types of outcomes that we agree we should avoid. So most of our Latin term canons are semantic canons, in pari materia, expressio unius, nocitur associis, and so forth. So let's proceed. We're going to start with in pari materia. And this is the idea that statutes on the same subject should be construed together. And courts presume that legislators use a specific term in the same way throughout statutes that relate to the same subject, and whether it be firearms or narcotics or securities or probate or whatever it is that we're talking about. So if there's an operative word that's really important in the statute, then courts will try to give that a consistent meaning in all of the statute sections on that topic. Now, a couple things to note here for my students. Modern codes sort statutes by topic. Remember that until the 20th century, this wasn't the case. Statutes were published chronologically by date of enactment. So this means in practice that for you as a lawyer or for a judge, that we're often applying the consistent meaning to an important term in neighboring statutes, right? So because the statutes that are adjacent to each other, if you turn the page in a statute book, probably the next page is about the same thing unless you've come to the end of a title or something like that. So so neighboring code sections, assuming that they're about the same subject, and they often are, we're going to give a consistent meaning for the terms. The same can apply, though, to subsequent amendments or new statutes on the same subject. This maxim can also apply when a term occurs in a statute in another title of the code that happens to address an overlapping subject. So, for example, let's say you have a term that's used in a domestic violence section of the penal code, and then we're using that term again. It pops up in a later title of a code, a separate volume that's talking about child custody and what to do in child custody cases where there's domestic violence present, and we may use a term again. The other thing I want to point out about in pari materia is modern statutes often have definition sections. So if Congress passes sort of major legislative reform, very often the opening section of the act is going to be a definition section. And to some extent, and that will, of course, override in pari materia. So if it says, for purposes of this section, this term means X, then the courts are going to apply that to to all the statutes that were part of that act. And in pari materia is a rule of thumb that kind of creates an imaginary definition section for statutes related to the same subject. And note that even if a court does not assume that the legislature had all the other related statutory sections in mind, that's if you read Sutherland's treatise, that's what he says, it might still make sense to adopt a consistent interpretation of the term for the sake of harmonizing sections and avoiding contradictory results, for simplicity and judicial economy, so that we kind of have a settled rule. Or for the sake of giving notice to the parties in the future about how to interpret other sections of the statute. Okay, next canon, expressio unius, which literally means the enumeration of specific items implies the exclusion of all the others. And as you can see, it's actually, this is shorthand for a longer Latin phrase. Now, what we're talking about here, this is where the statutes delineate or list specific examples of items that are included in or excluded from what the statute covers. This is, by the way, a feature of modern statutory law. And so if you think of law or statutes as almost a genre of literature on a sort of abstract level, a common feature of that is to have these sort of little rambling lists of, anyone who uses this or this or this or this or this to carry out a crime, and it'll list 10 different types of weapons. Or we do a case in my classes where it lists a number of different types of vehicles in a statute, and they're separated by commas. And very often, and if it stops there and says this applies to this and this and this and this and this, and it doesn't include sort of an extensive phrase that covers other scenarios, then we're going to assume that this is an exclusive list, that the legislature did not intend the statute to apply to other items not mentioned. In other words, when a statute starts specifically mentioning items of coverage, it carries this implication that if they specifically mentioned things, that they wanted to single those things out and not make it a general statute that applies more broadly. Ejusdem Generis, in some ways, goes hand in hand with this and covers the alternative situation. So this is where you have a list of several different types of, let's say, stabby weapons or different types of vehicles. And then we say, or any other blank at the end of that clause or sentence in the statute. And so we see a lot of cases, a lot of statutes. Again, this is a common feature of modern statutory writing, to list examples of things that are covered by the statute, and then end with, or anything else like this, or something, some similar sort of catch-all phrase at the end. And this is the one, whatever you're going to put in there needs to share some common trait with everything else on the list. And in my classes, I talk about how this, try to have students remember the one of these things is not like the other skit from Sesame Street when you were growing up. In other words, look at the list and ask yourself, what is the common denominator between everything on the list in this statutory clause? And whatever the shared trait is, if you're going to apply the statute to things under the or anything else, it needs to also have that shared trait. Please note that this is a narrowing statute. This will always be used to narrow the application of a statute. So one party that wants to extend the statute to something questionable, they're not going to want this. Criminal defendants, on the other hand, are kind of likely to invoke this statute, and it's often going to be the prosecutor who's saying, well, come on, they committed a crime. It's not one of the things on the list, but it also committed the crime, and the defendant will argue, no, I didn't commit it. It has to, under this canon, it has to share a common trait. Now, please remember the canons are not mandatory rules. These are sort of conventions or maxims that judges have followed over time. There's debate among scholars about what to call these. Are they rules of thumb? Are they sort of commonsensical, almost like rules of grammar and linguistics, or what are they? But one thing they're not is binding precedent. They're convention that courts employ in part of their interpretive methodology. Noscitur associes. This is sometimes called the associated words canon. And this is the traditional rule that we recognize words by their associated words. That is, words take on meaning from the surrounding words in the sentence or paragraph. On a very basic, oversimplified level, this is something that you've probably, a common sense rule you've always said, that you have to take words in their context and in the context of which they were spoken. And so for example, if I say, I love guacamole, and I love my dog, and I love my kids, obviously, hopefully, I mean love in a different sense, in each of those sentences. Note that this and Ejusdem Generis often overlap significantly. And so that was but Ejusdem Generis only applies in statutes where we have one of these catch-all phrases at the end of a sentence or any other thing. In Noscitur is going to apply where we have a word like agreement that could be ambiguous. And so what are we going to do? We're going to look at the other words right around it in that sentence or the surrounding sentences, and again, use it to infer a narrower meaning, typically. The surplusage canon. In my classes, we don't really use the Latin form of this, verba cum effectu sunt accipienda. This assumes that every word and every provision is to be given effect. The way I usually explain it in class is don't interpret one word in the statute in a sentence so broadly that it makes the other words in the statute redundant or meaningless. And there's case examples of this where it's a list of terms sometimes of things that where a party has to file a type of form or has to make certain disclosures or something like that, and someone wants to stretch the meaning of one of those terms to cover a sort of an attenuated case. And the question is, if we do that, then it makes other words meaningless. By the way, this is, for linguists, one of our more controversial canons, because the fact is most spoken and written, especially spoken language, but also written language, has a lot of built-in redundancy, which greatly aids with comprehension. The fact is that we do use more words than necessary, and sometimes it makes it easier to understand. So it's, but this is assuming that every word that's there is there for a reason, and that we should, and sometimes it will seem like courts are reading way too much meaning into one particular word. Okay, saving clause or savings clause. I hear lawyers and use both. I read courts referring to both. The traditional understanding of a saving clause from Sutherland is that when a new statute is, let's say, repealing or amending a previous statute and getting rid of a lot of its provisions, there's often a proviso that excludes certain things, especially if it's a section about giving certain powers or creating the existence of a government office or agency or something like that. And this sort of saves that from the repeal. So let's say that we repeal the Clean Air Act or something, which the EPA enforces. If we pass a simple statute saying we hereby repeal the Clean Air Act, it would be pretty typical to include a nothing in this enactment does anything to limit other statutory powers of the Environmental Protection Agency or something. So that would be a savings clause just to avoid confusion that maybe somebody has lost their job because we repealed a statute. Now, I also hear this phrase and see in writing this phrase savings clause being used in modern sources to refer to what might more precisely be called a severance clause. And this will say something like, if any individual provision or subsection of the statute is found to be unconstitutional or invalid legally, the rest of the statute remains valid and effective. And you may remember that one of the issues with statutory construction is this idea of severability or severance of the statute. And so if we find, let's say, one particular clause of the statute unconstitutional, does that mean we have to throw out the entire statute or not? And if you remember from your constitutional law class, the Supreme Court case about the Affordable Care Act, there was a large section of that case that was about whether the individual mandate would have been severable. And a lot of the oral arguments in that case were about, if we hold that the individual mandate is unconstitutional, do we get to save the rest of the Affordable Care Act? Okay, the last antecedent rule. This is a traditional canon of statutory construction, and it refers to the idea that relative or qualifying words or phrases are to be applied to the words or phrases immediately preceding them. And an exception to this would be cases where the opposite result is clearly required by context or by explicit verbiage elsewhere in the statute. And for my students, I want to flag for you that after the New Deal era, so in the second half of the 20th century and in the last couple decades, this rule has probably taken on more importance because so many federal statutes after the New Deal throw in the phrase "in interstate commerce" at some point, and sometimes it's at the end of a statutory clause. And so then so it often comes up, does "in interstate commerce" refer to every other verb or act or clause that precedes it, or only the immediate antecedent one? And the last antecedent rule says that it only applies to the one immediately before. And so I have an example from a case here in Texas. The said limits of the city of Corsicana may be extended so as to take in other territory by ordinance duly passed by the commission in the manner for and as prescribed by the general laws of the state of Texas. And so that's a string of confusing clauses. And the question is, of the second and third clause, do they refer to extending the limits of the city of Corsicana? Or does this mean that the city of Corsicana can extend its limits in the manner prescribed by the general laws of the state of Texas, or that the ordinance has to be passed by the general laws of the state of Texas? And so this can get very confusing. Another point I want to make is that in criminal cases, the person arguing for the last antecedent rule is often the prosecutor, because they want a final clause to refer to as few other things in the statute as possible, so that other parts of the statute can be given a broader meaning. In other words, we see a lot of cases where criminal defendants are arguing against the last antecedent rule because they want to argue that it essentially creates another element, doubles the elements that a prosecutor has to prove if we have to prove that every element of the crime was done in interstate commerce, not just the last part of the statute. And by the way, when we get later on to the rule of lenity, we see a number of modern cases where between the majority and the dissent, either the majority or the dissent is following the last antecedent rule, and the other will follow the rule of lenity, which favors the defendant. We didn't talk about this Latin phrase in my classes, but we did talk about how the idea that the specific could govern the general. And so this can take a couple of different forms. First, if there is a conflict between a general provision and a specific provision, the specific provision will prevail. Also, specific provisions in the statute can help interpret or narrow the meaning of general terms in the same section or the same statute. This canon kind of rests on the assumption that specific terms are more specific terms are more deliberately or thoughtfully chosen by legislators. So legislators may have thrown in a vague word, kind of not thinking through all the implications, but if they picked a precise word or a specific word, it seems more likely that it was deliberate, that they really meant to use just that word. A flip side of this, another way to justify this kind of canon is that courts are more likely to be accurate in their reading of specific terms than general terms. In other words, a general term, let's say, could mean 10 different things, but a specific term can only mean one thing. Well, we're not as worried about the court. If there's only one possible meaning of a word for the specific one, the court's probably going to get it right. They can look it up. And the general word could mean a lot of different things. And so it's possible that the court is going with a different meaning than the legislature would have intended. If you want an even more kind of general version of the specific governs the general, you could think of a way of reading other authoritative documents where we might say something like interpret confusing passages or sections in light of the clear ones. And frankly, the specific is more likely to be clear a lot of times than the general one. Okay, statutes and derogation of common law. We don't spend a lot of time on this in class because it's not it has fallen out of use. And I want to explain. This is an older canon that said the courts should narrowly or strictly construe statutes in derogation of the common law. And many courts explicitly don't follow this anymore. And in fact, in Texas, we have a statute that says that by statute, the courts shouldn't follow this canon anymore. But at one time, the US Supreme Court said no statute is to be construed as altering the common law further than its words import. It is not to be construed as making any innovation upon the common law which it does not fairly express. And so the idea was that legislatures could still enact laws that replace the common law and reverse or change or narrow the traditional common law rule, but the canon would require an express statement in the statute that the legislature intended to set aside the common law rule on the subject. Please note, this canon was far more important in previous centuries, like the 14th, 15th, 16th, and 17th centuries, when judge-made law or common law was the norm and statutes were the exception, right? So Parliament only occasionally passed a statute, like the Statute of Frauds, and most of our law was judge-made. And so when we, basically this canon would have said, so we want to preserve as much of the common law as we can, in spite of whatever's left by this, this enactment, or the idea that we want to have this statute bring as little disruption to our legal system as possible. Again, now that we live in an age of statutes, this has sort of been abandoned because we now have had over a century of most areas of law being heavily affected by statute. We don't have that many pure common law areas now. We do have some but most of our common law actually works within the framework or filling in the gaps in statutes. And so because now our statutory law has been going on for generations, this canon is seldom invoked and kind of obsolete. Redendo singulus singulus. We didn't talk about this even once in my class. And this is very confusing, and I think you'll go your whole legal career without even seeing it. This is the idea, literally in Latin, this means referring each to each. This is a method to limit the effect of expressions that would reach too far. In other words, we use this canon essentially to narrow the reach of some of the really broad general terms, especially when they're in the opening section of a statute. So remember, a lot of statutes open with a broad, sweeping assertion of any person or anything and or all things like this, and then it gets narrower and narrower as we go along. And so what this is saying is that if there's several words granting authority or obligation, each of those words should not necessarily apply to everything else in the statute. And we're going to limit the words giving power and authority to particular subjects and those requiring obligation to other subjects. And so this is also true if we have a statute that in its opening statements giving broad authorization and then also creating obligations and responsibilities. We might end up applying those to different enumerated or delineated parties mentioned later in the statute. Okay, enough about that. May versus shall. This is pretty obvious, I think, to my students, but you should be aware that there are cases where courts kind of go on and on about this, and you can find some law review articles and treatises, sections talking about may versus shall. The general rule is that shall and must express a duty, obligation, requirement, or condition precedent. In other words, shall means must, and may is permissive. And so this confers a power, authority, privilege, or right, as opposed to a duty or obligation. May not, must not, and shall not prohibit the exercise of power, authority, privilege, or right. When does this come up? Sometimes when you see statutes about, say, a licensing board that gives licenses to nurses or doctors or lawyers or something like that, and whether they have to let's say, respond to a complaint or a grievance or an application within a certain day, and then courts will really scrutinize whether the statute says shall or may. And versus or. Most of the time, this is pretty clear. And is conjunctive, connective, and additive or inclusive, and or is disjunctive or alternative and exclusive. When does this get confusing? When you have a statute with a long list of terms, especially bullet pointed or lettered, of things, items or persons covered, let's say eligibility for a certain government benefit. And it's easy to lose track of or find it confusing that at the end it says or before the final term. Always, if nothing else, as a lawyer when you're in practice, pay attention to whether at the end of a long list it says or this, and if that means that all of the things above, you only need one of the items on that list, or do you need all of the items on that list? Again, most of the time, this is pretty clear and obvious, but we have some cases where it gets confusing and courts have sometimes reached counterintuitive outcomes about the meaning of and or in a statute. Okay, the substantive canons. We're gonna, the absurdity doctrine, this is pretty easy for students to understand. This is the idea that courts should not apply a statute in a way that produces an absurd result. Occasionally, you'll see a court saying that they want to avoid absurd interpretations, but this is really less of an interpretive rule and as much more of an interpretation of an implication. So we're assuming or we're implying that the legislature would not have intended the words of this statute to be applied in a way that produces an absurd result. And so I want you to see that this is different from talking about where words occur in the sentence and how a consistent use of meanings of words. This is kind of a policy judgment that the legislature didn't want Crazy Day to happen in our courts. And so we're going to, if the result in a case is too preposterous, we might invoke the absurdity doctrine and say, you know, whatever this statute means, it could mean a lot of things we don't even like or that are hard to swallow, but it definitely doesn't mean this. Okay, the rule of lenity says that courts should construe ambiguity in the language of a criminal or penal statute in favor of the defendant. Note, in some cases, this ends up being opposed to the last antecedent rule. And also, please note, this is the gotcha question for exams and stuff like that, is the rule of lenity only applies to criminal cases. So we're not going to construe ambiguity other times in favor of defendants, only criminal defendants. And there's a few reasons for this. Sometimes this is justified on the sense of sort of leveling the playing field between the formidable power of the state to lock you up or take your life away, or, and things like that, the coercive power, the power of the state to use force, and the kind of helpless lone individual when you go up against that as a criminal defendant. Or it could sometimes be justified as, you'll see this in the case opinions, as it's as sort of a due process or fairness idea because of notice. In other words, if there's ambiguity, then people couldn't have known what they were doing for sure was illegal, and therefore we should give them the benefit of the doubt. Rule of lenity, statutory ambiguity, we give the defendant the benefit of the doubt. The ex post facto. This is a rule of construction that forbids enforcement of a criminal statute enacted after the commission of the crime itself. In other words, no retroactive criminal statutes. Please note that we have a presumption against retroactive application of civil statutes, but not a prohibition on it like we do with this. Now, please note that this is a constitutional rule. It's not just a judicial maxim like many of our other canons. It's right there in the Constitution. In Article 1, Section 9, Paragraph 3, we have an ex post facto clause. Please note that some courts have applied the ex post facto clause to changes in punishment and not merely the criminalization of certain activities. In other words, we take something and we convert it from a misdemeanor to a felony. Does that apply retroactively? And so be careful with this. We do get a lot of live cases about the ex post facto clause. We get fewer live cases about the Bill of Attainder clause, which is also in the Constitution, near in the same article and section as the ex post facto clause. This is a legislature's pronouncement that specified individuals are basically outlaws, right? They just designate, like, if you remember the Russell Crowe movie about Robin Hood, in one of the closing scenes, the wicked king pronounces, just declares or decrees that Robin Hood shall be a permanent enemy of the state or an outlaw or something like that. And the legislature could do this too. Parliament could do it. And the framers of the Constitution really didn't like this because it was basically a way for the legislature to punish political dissidents. And so so we don't allow these types of laws. The avoidance canon, and this is something we do spend a lot of time on in class, the avoidance canon refers to the preference of courts to interpret a statute in a way that avoids constitutional problems, and it can also refer to the practice of striving to decide a case on the merits or procedural grounds without reaching the potential constitutional issues involved. So in your casebook for my course, it talks about how the traditional avoidance canon required a court to choose a different interpretation of a statute. Let's say there's a few interpretations available, only when one interpretation was actually unconstitutional. In other words, if you have a few possible interpretations and one is unconstitutional and would create constitutional problems, then obviously we're not going to pick that one. That was the sort of mild avoidance. The modern avoidance canon, which is a bit more robust, tells a court to choose a different interpretation if we even have constitutional doubts. And so, so in the traditional avoidance canon was where it was very clear we would have to invalidate a statute if we go with a certain interpretation. So let's interpret it in a way. This is sort of like saving the statute or avoiding having to invalidate the statute. The modern one is basically saying, if we do this, then it raises the specter of constitutional issues and we don't want to go there, so let's avoid it like by a mile. Also, please note that there's a general preference. If the court can decide a case on procedural or technical grounds and dispose of it and leave the constitutional issues for another day, they usually do that. And so, okay, and that is our conclusion about the canons of construction.